the recording, we're going to talk a little bit about privilege, and I sort of warned the people here that we were going to start by talking about, I'm going to do a little bit. Those that have skimmed the lessons maybe know the answer, but don't give away too much right away. But I'm going to say, if you didn't know, if you hadn't read anything or you didn't know, you had no experience, if the concept of legal privilege was totally new to you, and I'm just using this as a memory tool, not a direct teaching tool, but what goofy thing that is not really legal privilege, what might you have thought if you'd have never studied it at all? What would you think legal privilege was?
Okay, anyway, what were you saying?
I heard something. Is that Cassie? I heard somebody talking, but I couldn't understand it quite. Not audio.
Hi, sir.
Go ahead.
I was just saying hello.
Oh, you're cutting out. I'm sorry. Type it in the chat, I'm afraid. We'll have to do that. But anyway, I'm going. I'll also see if this will help the audio, because I always stop the videos in a bit. So I'm going to turn off my video and anybody else's. Now let's see if our audio is a little bit better. Please keep audio off until you're ready to talk. Okay. I'm going to try to log on with a little better audio if somebody is. Anyway, what might you think, and you can just type it in the chat, what might you think privilege in law would be if you hadn't read anything? Okay, yeah. And actually, Leah, you're very close to the truth. Technically, that's not privilege, but that is such a closely related concept to privilege that it basically, if we weren't being a little bit technical, you'd say that's so closely related to privilege that it is the answer, but it's part of the answer. What Leah said, what an attorney knows about his or her client is private, but privilege doesn't come up quite so generally. It is private, but it doesn't. When we study privilege, we're talking about the privilege that you assert in court. You say the client reserves the privilege, and so let's say that a person's former lawyer is called to testify, and let's say that I represent the person who formerly employed this lawyer as the lawyer. Okay, put it up there. Board. Who wants to play the client? Because it's more fun with names. Who wants to play the client? Okay, Whitney, okay. Opposing lawyer. Okay. Kirk, client's lawyer. Okay. And then we've got the former lawyer. Okay, so we'll have Whitney Amy, you can be the former lawyer and we'll call you to testify. How's that? And Matt, will you be the opposing lawyer? Okay. Okay, Matt, ask Amy a question that we'll probably object to. Something about something that would be in the former lawyer's knowledge. Amy used to represent Whitney in this same litigation that we're in now. Amy's being, or excuse me, Whitney is being sued for an auto accident she didn't actually cause from our point of view, but she made some admissions perhaps to Amy about her lack of attention and so on, which we think is irrelevant anyway, but we don't want Amy to testify about it, okay? So ask the question, Matt. You can do it right in the chat or out loud if you have good sound. So Amy is has been called and she has taken the witness stand. And she has testified so far that she was the former lawyer for Whitney, which was public since she represented Whitney in court in the first part of this proceeding. And that was okay because that was not, we did not claim privilege at that point because that just set the stage. We more or less stipulated to that. I told the judge, I said, I'm not objecting to Amy giving her name or that she was the former lawyer since that's a matter of public record. So now you ask the question I consider to be rude. I don't even know why you're asking it. So Matt is going to ask, just type something in, ask Amy something that Whitney told her. What did Whitney tell you about her auto accident? Okay, Amy, Matt has asked, Amy, did Whitney tell you anything about other activities she may have been doing while driving that could have distracted her at the time? Objection, we claim the privilege, and of course it's not the privilege against self-incrimination. It's not like criminal court, this is civil court, but we claim the privilege, attorney-client privilege. Your Honor, we didn't waive it, because the fact that Amy was the lawyer was not privileged information in this case. It was not a secret consultation. This was court. So we didn't waive it. We didn't give it up. And now we assert it. And then of course, what does the judge do? The judge says, well, counselor, they have asserted this, and you haven't denied that this person was the attorney. In fact, this Amy was the attorney in public record. It's obvious that Amy was the attorney. Amy was not talking over the back fence with Whitney outside of the legal context. So now Matt asks, was anyone else in the room when you talked to your lawyer? How about asking that, Matt? Because what you'd like is a waiver. This is why you're not supposed to usher in somebody's cousin and friend and the other friend and the neighbor during this confidential consultation. Okay? And lawyers sometimes forget this. Lawyers can screw up. Don't don't shout it out loud to the lawyer in the presence of other people, but pass the lawyer a note or wave to him and have him come and see you in the outer office or something. But don't wave the yeah. So Matt asked, "Were you alone?" Okay, and then Whitney, excuse me, Amy. Amy says my legal assistant and paralegal were both there. Okay, and I know I'm doing your work for you, Amy, but so the answer, legal assistant and paralegal. Who would guess that that would waive the privilege or it would not? Yes, no. Yes, it would waive. No, it would not. So Amy says, no, it would not waive the privilege. Aren't we glad, though, that we did not have Whitney's cousin, her friend, her neighbor over, somebody else? If Whitney had been in a wheelchair and ailing or whatever, I think, and had to have a nurse there or something like that, I think we probably could get by with that in an emergency. And I think that we could possibly extend the privilege out, but unless there's a very dire circumstance, Whitney should talk to the lawyer only in the presence of the lawyer's staff members that are confidential staff members, okay? Yeah, and Amy, I'm going to instruct Amy not to answer. I'm going to, actually, I can't instruct Amy not to answer. What I'd say is, Your Honor, same objection. The judge says, do you have any questions of this witness other than of what Whitney discussed confidentially? And Matt, I'm just going to, because of time, I'm just going to tell you, no. Your answer is no. No, you don't have any other questions. So the lawyer's going to tell Amy to step down. Okay. So Amy, you are done testifying. Yes. Yeah, it could be possible that the privilege would be waived, and that's bad for our side. What we'd like is to be able to retain the privilege, so anything that was told would not be allowed. Now, I practiced law for quite a few years, and I don't recall a successful attack on privilege, but of course I was not there with all the other lawyers' cases in some of these complex matters. Where I think that we're going to run into it would be maybe the type of things where you're going to run into it might not be strictly speaking waiver, but it would be where the person never was the attorney. Best example that you're liable to see in real life, I think, would not be waiver. It would be the fact that this attorney was not the actual attorney for this human being. So we have, let's say that, and I'll use some of the same students that are playing along, but Matt is the corporate executive, corporate attorney. And we're talking about corporate matters. Unfortunately, Matt somehow, because he's such a highly placed executive and we've worked together, he tells me some things he should not have told me about his own personal business that actually kind of goes against the corporation. He's upset with what the board of directors did. But unfortunately, I'm going to have to, I keep trying to remind him, remember, I'm not on your side against the board of directors. I represent the corporation itself. So whatever you tell me is not privileged, and he talks anyway because he's upset. Yeah. Okay, it did come up. Privilege was waived. Matt brought up an example. President of a company discussed legal matters with his lawyer with other people at the table. Okay. So anyway, that's probably how it's going to happen in real life, is more of a corporation matter, or I suppose it could be a government matter. The distinction between being the lawyer for an organization and being the lawyer for a person is very important. So we want to know the where the privilege works. A lot of the practical knowledge is to know that the privilege is not terribly leaky. It's not going to come up every day, but you do want to safeguard it. You don't want to get sloppy. And it's not you necessarily, but or let the lawyer get sloppy. Okay. So yeah, Nadine, that's a good question. And you want to find the fundamental answer to that before talking to the lawyer yourself. Not that you would necessarily be in that corporate context where you have to determine that, but if it's just kind of strange because an outside lawyer, for instance, could be hired by an executive person, but if the agreement is on behalf of the corporation, he does not represent that executive. Yep. You want to look in the actual fee agreement and see if it's an outside attorney. If it's an inside attorney, the inside attorney, to my knowledge, the attorney who is an employee of the corporation never represents various corporation executives personally. The inside attorney has to be able to be independent of them and not act as their personal attorney. It is similar for government attorneys, and I think some people who are public attorneys, they'll get confused. I think because they form a working relationship, they go off on tangents. They go one side or the other. You do form a working relationship. You know, I was a government attorney for a year and a half as a assistant county attorney, and maybe I was too independent. I don't know, to get along with everyone wonderfully, but you know, my version of it was that I was the public prosecutor. I was not the prosecutor who represented the child support officer, the deputy sheriff, you know, the person in charge of the social service, or various other people that came to my office. I didn't represent them. I represented the public. Yeah. And if you have to, there's a possibility, which I still think was remote. I never had to prosecute somebody who worked for the same government I did, but I had to realize that that was a possibility. Okay. We need to be able to talk about work product too, which is kind of subtle. And those of you who are just starting your studies, I think work product is kind of difficult in a way. But one of the things you want to do when you take a course like this is write down basic terminology and don't sweat the possible little exceptions and complexities. Don't get all balled up with those until you get the basics down. So basically, what is a privilege? It's like we demonstrated. We asserted the privilege and we won. The other side tried to show that it was waived and they lost. Okay? Yeah, and a couple of students have talked about working for government law offices. Yeah. Now, if somebody in the sheriff's office, well, I will give you an example without stating individual names, but individual in the public welfare office, they wanted me to prosecute somebody criminally who was actually, to the best of my knowledge and belief and understanding, was innocent of a crime. A complex regulation, and I let the person go. I dismissed it. The state and national prosecutor's manual said that I had to do what was right, even if it went against the government people that cooperate with me. But I got in all kinds of trouble for that. And I think I realized that my that my life as a public prosecutor was probably not going to be really long, because they wanted you to play ball or whatever, I suppose. But they wanted me to make an example of someone who was, to my mind, it was not guilty, did not have criminal intent. And so there's an independence there. But who actually regulates the practice of law in Minnesota? It's the Supreme Court. It's not the legislature. So that's an important point. Which is primary? Primary law is actual law, enforceable actual law. Secondary explains or comments on the law. So an article in a legal magazine So article is secondary. Statute, case decisions are laws. And what are they? They're primary. Okay. How about the ABA rules, primary or secondary? We really want to go into primary when we can, but yeah, secondary, not the law, never enforceable. No, absolutely not. The ABA the ABA includes some scholars and some crackpots and some political hacks. Uh, and have you ever tried to get medical treatment by the American Medical Association? Where's their hospital? They don't have one. The ABA, where's their courthouse? They don't have one. Okay? They don't have a legislature, and they don't have a courthouse. Okay? It's like trying to buy a car from the American Manufacturers Association. They're a lobbying group. Okay? And many lawyers never belong. I belonged for about a year, and they burned me out. I guess I like some of their articles. Some of their scholarship is good, but some of their attitudes are bad. Yeah, and they recommend laws. You might say they recommend what the legislature should do, but they have hurt. They've helped the law in some ways, hurt it in others. So the thing I don't like about it is the mealy-mouthed, what do you want to say, namby-pamby way they deal with delay. Their version of the anti-delay rule is silly and bad. They because they are, and this is my bias. I don't want you to go with my bias. This is my bias, but I think that the ABA has specifically leaned in towards large law firms that like to delay for a living because their recommended model rule doesn't squash delay like it should. And a lot of the state Supreme Courts have gone along with being marshmallows. Am I laying it on the line enough to be clear? Okay. Missouri, for at least quite a while, Missouri basically said delay was bad, even if it helps your client. If it hurts anybody else, you're not supposed to do it. And that's not word for word what they said, but they considered, the state of Missouri considered, and I think to some extent they still do, they considered delaying anyone's cause as a violation unless there was a very good reason or excuse. And Missouri was the only stand-up state I know of for that. I don't know if they still kept that, but the ABA is a marshmallow with delay because I think the people that run the ABA think delay is a good game. And again, don't go by what I say on stuff like that. Talk to, read articles by lawyers that have the opposite point of view to mine, and be prepared to argue for their side. Okay. They could probably even show that I delayed at times. That I'm talking out of both sides of my mouth, and certainly I did delay, but I thought my delays were totally justified. And many times my client and I agreed that we were not going to do any delaying tactics. Because I still feel it's unethical to use delay as a tactic. Okay. But so just so you know that, any organization that you join, though, is going to have, or that you cooperate with or get information from, almost any organization in this world is going to be flawed, including if I started an organization, it would be flawed, okay? We would screw something up, okay? And hopefully you would catch it. So basically the attorney-client privilege, this is the starter concept to it. This is not actually the exact thing that is the privilege. Asserting the privilege means that somebody cannot testify. And here's why there's a privilege. It's to encourage full and frank communication between attorneys and their clients, promote broader public interest, the observance of law, and administration of justice. So basically, that's okay. Yeah. Yeah, you're correct.
Mr. Olson, can you hear me?
Yeah, I can.
So, like, it was a question on the quiz, and which of the following was an exception to confidentiality? So, if the lawyer assumes that it's morally required for him to disclose that information, is that not allowed?
That's not enough. That's not enough to create an exception. I guess I could say I disagreed with a lot of clients on moral truth. I mean, I give you a simple example. I represented a lot of folks who were reluctant to pay their child support. That's why they were in court. Did I agree with that? No.
So, how do you know?
You know, so basically, you have to use the exceptions. The only thing you can use as a lawyer to testify would be the exceptions in the law that require a person to violate the privilege. And I would be very, very, very reluctant to testify against any client. Unless the client specifically waived it and said, I want Mr. Olson to testify, okay? Because there's a sacredness to being able to be their confidential advisor, and of course I'm no longer doing that, but when, you know, the privilege still applies to me though, because if somebody from 20 or 30 years back says, well, now there's a new case, and I don't want Mr. Olson to testify about the stupid reasons that I wouldn't pay my child support. Actually, I've forgotten all of that, and I don't, you know, those files are gone, shredded, whatever, but even if I knew the answer, I wouldn't testify to it, okay? Oh, okay. The question had to do with whether it is enough for the lawyer to think that it's morally required to talk. No one would ever talk to lawyers. Lawyers would never hear the truth if lawyers could be called on to testify to it. They would never hear the truth. It's bad enough already. A lot of times they don't hear the whole truth, which makes the lawyer look foolish in the end, because the lawyer goes into court, and because the client did not tell them the whole truth, the lawyer can be, upended, blindsided, because the client did not tell the whole truth. Hey, nobody wants to show up in court. Clients don't think ahead very well sometimes when they're under stress. So if the client's own sister is going to testify against him, and he's embarrassed and doesn't want to tell his lawyer, he should tell his lawyer anyway. Hey, by the way, my own sister is going to testify against me because she thinks this and this, and she basically has dealt with the same issue, and you know, she's as upset with me as this other person is, and she's gonna, he should say that to the lawyer rather than withhold it, because the lawyer should not be shocked and surprised. And it might be a simple, easy case like the fact that a person has received their notice that their driver's license privileges in the state have been revoked, something like that. Your privileges have been revoked. Well, his sister saw him open the envelope and throw it away. It was sent to the wrong address. It was sent to her address. But now he admitted to her that he received it. And she's going to testify against him, even though the state has lost the proof that they ever mailed it. Well, so he could lose a misdemeanor trial, but he won't tell his lawyer about it. But if the privilege is not observed by the courts or by the lawyers, then nobody's going to tell, I shouldn't say nobody, but lots of people will not tell the lawyer the truth. Or if they do tell the lawyer partial truths, they won't tell the lawyer enough truth to where the lawyer can really manage the courtroom very well.
I had another question. A scenario where, let's say you represented a client on a previous case, and through that representation, you learned that the client is, fraudulent or, does not claim to do what they say they do. But that case is already done, and another case pops up with the same client, and the client asks for you to not be part of the case because they know, that your relationship with them previously was not good, and they know their history. So can they ask for you to not work on the case? Would that be valuable? Would that be considered a conflict of interest?
You mean not work on the case for the same client, or not work on a similar or same case for the other side?
Different case, same client.
Okay, well, my old clients usually came back to me and they would want me to work on the case again for them.
Not for them.
Again, for the other side. Well,
initially it was for them, so you learned certain things about that client, which were not positive.
Okay.
The next time around, you're against them, so you can use that information to your benefit, or you already made an opinion about that client,
Okay, well, that is a confidences or secrets conflict of interest. So the client is perfectly within their rights. The lawyer and the staff should have figured out that this new case should be turned down.
Okay.
So let's say I represented this client. This client the landlord was trying to kick this client out for destroying the apartment, okay? And of course, the apartment is not really totally destroyed, but it's damaged. This person has habits of kind of destruction, okay? And so this person gets evicted, and of course, or I should say, they attempt to evict, and I managed to help the person avoid eviction, or we settle the case. Okay, later on, the person is in a different apartment building with a different landlord, and I represent the landlord, and I realize this, I suppose if I messed up and I didn't do a good enough conflicts check, I could possibly be trying to evict my own former client. And then the former client says, no, you know too much about me. I'm going to bounce you out. Meaning that I can't represent anyone in that case. And that's what Aroni is bringing up, is the confidences or secrets. Okay? Once a lawyer knows the confidences or secrets, the lawyer is foreclosed against, cannot represent anyone except the client in a case that might involve that confidences or secrets. Okay. Yep. Work product is interesting. And this is also, this work product, it does create complexity, but necessary complexity. Because we have to be able to develop case strategies without having the other side look over our shoulders, okay? So we say, here's a good bad question. Why have you chosen not to do a deposition of Edward Y? And my answer is none of your business. Okay. That they cannot ask for. Okay, so if they ask me for the facts that were given me by Edward Y, I have to answer that. But why have I chosen not to do a deposition of Edward Y? I don't have to answer that because it's my work product. My notes as a lawyer, of course, my position is my notes as a lawyer, I don't have to give them to anyone. But I found out in most states, you do have to give those to the client. Can you answer it if you choose to? I suppose you could, but it would be bad client relations. The client has to believe in the attorney, that the attorney's strategy should not be revealed to the other side. Have you ever played cards, Whitney? You ever played a strategic card game or something like that, a board game? Okay. Would you reveal to the opponent why you're doing stuff? I don't really want to tell them why I didn't do a deposition of one person or why, you know, if we're in court and they say, well, work product basically is just that what we create is ours until we belongs to our team until we choose to reveal it. I'm not sure. I'm not familiar with the term immunity with work product. I wouldn't usually say immunity. I would just say that we object to providing the information due to work product. The part of the problem with work product in this course is a lot of you have not had civil litigation. So unless you had experience in a law office, we're kind of getting ahead of ourselves. So let's put it in context a little bit. So before a trial, can ask us questions. And we have to answer them. One controversy that came up was they wanted to know level of education, and due to the personal relationship of the parties were closely related, you know, one against the other. Just asking level of education was so offensive that the client did not want to answer any of the other questions, but they had to be answered. Ethics can forbid them from using information accidentally leaked. But our job is not to accidentally leak it in the first place, our big job. Because that's going to depend on the exact rulings of your state's laws, your state's Supreme Court, to determine that it was accidentally leaked and whether the ethical rules require the lawyer not to use it. How do we know if it's strategy? How do we know that they're not using it? I think it's going to be very difficult for them to unlearn information. That's not the same as privilege. That's just trying to avoid having everybody in on the conversation that may have to do with technicalities that are going to mislead the jury, or the jury is not entitled. You have to approach the bench in a jury case especially, because the jury should not be hearing the arguments about whether the evidence should be out there in the first place. We don't want the jury to be prejudiced by the fact that people are asserting their rights, okay? But what questions do we have to answer that the other side can ask us? Factual questions. Are the actual case, not the strategies. I guess let's say that something is unfairly prejudicial. We're in a child custody case, and something that this parent had done 20 years before. We're dealing with, let's say, two 40-year-olds in a custody battle, and something that this person did as a older teen 20-some years beforehand is going to come up. It's embarrassing, but it has really no weight. It's just meant to intimidate the person, the fact that we get to talk about it in open court and embarrass them. So we say, can I approach the bench? This question is irrelevant, immaterial. It's being brought up just to embarrass and intimidate my client. And the judge says, well, what's the nature of it? And then I might explain the nature of it and say, well, I'll explain what it is. And the judge looks at the other side like they're crazy. Why would you bring something like that up? You know I wouldn't allow that. I don't care what goofy thing this person did when they were 19 years old. We're dealing with an adult problem that we're dealing with right now. Okay? And a good judge isn't going to allow something just to be used to embarrass and humiliate the other side, especially when it's not at all relevant to the question. It's just embarrassment. If it's mildly relevant, the judge may still not allow it because, especially if it's a judge, well, especially if it's a jury trial. But even if it's a judge trial, the judge might say, listen, there's no jury here, but I don't have to listen to this either. This is junk. You think I'm going to be emotionally swayed because this person made a fool of themselves at age 19? I don't think so. So there is all kinds of discovery available in a civil case. There are some in criminal too, but civil case and family. Yeah, I'm going to defer on grand jury, Nadine, right now because we're talking. We want to get in work product, and we're really not talking about work product in a grand jury. Can I defer that a little bit? Yeah, grand jury is kind of an oddity. It's not really a fair trial. That's okay. We want to really think about civil cases here for this kind of a thing, for work product. Work product is not going to come up in criminal law, I don't believe. It'll be civil and other matters that are basically civil. Under family rules or juvenile rules. So basically you have a civil case. One of the things that we do is, one of the things we tell clients, and it should be in your handbook, you have a civil case, and the client says, well, should I create a document for you? An official type document? And we say, no, I want you to write a letter to me asking for legal advice. So it's a new thing. Now this cannot disguise something as work product that is not work product. So my request to the client is to do this. This is for new writings. For something new you want to ask me, write a letter to me that asks for legal advice. Do not create an official business document. If they create something called a report on report on the incident and dispute for a company, they create an official looking document, the judge is probably going to require us to supply it. Because then it looks like something called a regularly kept business document. And we'll say, but hey, Judge, we don't want to disclose that. That's brand new. That was just done for attorney-client. And he said, well, it doesn't look like it. Turn it over. It sounds like a regularly kept business document. All disclosed. So we just blew it. If we told them, the lawyer told the client to go ahead and create an official business document, but the letter will not be disclosed. Asking for legal advice. We don't have to disclose this. So we win. We win on what? Work product. This is our current thinking on the legal case. Conferences. Okay. So letter asking for legal advice works. Official business document would be disclosed. Any questions about this? I realize this is way past folks maybe that have not done any civil litigation stuff yet. But it's very difficult to understand work product if you don't understand the context of it. It just seems like words about other words. Yes. But we want to make sure that anything we produce for strategy clearly is that and isn't something else, and is not going to be seen as something else. But we also are not going to unethically claim something is legal strategy when in fact it's an old record. We can't slap a new label on an old record that they're entitled to, okay? Let's say it's an employment litigation. You can't take, it says employee record, AG record. That's the initials for the employee. I'm just a fictional employee of incident. So you have the employee record of this. We can't just slap a label on it saying, keep for attorney, strategy, doc. That's unethical. We can't do that, okay? This is something AG and her lawyer or his lawyer are entitled to discover from us, okay? If we put on a new label, you know, July 6th, 2020, and we can't do that. Is it starting to come into, starting to make sense now, folks? Those of you that have not done this kind of a work at all? New evidence, we will have to disclose that if it's actual factual evidence. It's not a gray area, really. You have to be either ethical or unethical. Each thing you do is ethical or unethical. I don't think it's a gray area. But it requires that we do the right thing and think about it. It's just the what we prepare. Our mental impressions, conclusions, or opinions. Let's say that I tell, let's say that I talk to Nadine and Haroni. Let's say that you two are working for a company and you are the representatives of the company that I'm working with. And I say, we got a bad case. We should settle. If they come down to $250,000, let's pay it. That's my mental impression. And here's why. I think that the jury is going to believe their lead witness. Their lead witness is a killer. I mean, I don't know how we can break that person down. I tell you that. And I even write a letter and sign it that says that. You don't have to disclose it, and neither do I. Okay? If, on the other hand, you show me, you bring in proof that our company that we're trying to help lied about things, had a process of lying about the danger of their product and so on, that factual information we're going to end up having to disclose. They did not warn the public about something we're going to end up having to disclose. And this is kind of a difficulty. I wouldn't say it's a true gray area. Inadvertent disclosure, you brought this up before, may not waive the privilege. So may not waive is a double negative, which requires analysis. May not waive. So may not waive means keep, right? May keep the privilege. So sometimes you almost need to chart it out. If you're working late at night on legal stuff, chart it out and you say, and try to translate double negatives into a positive when you analyze them, okay? May not waive. It sounds like you have to be very careful with the word waive. Waive means give up, basically eliminating the privilege, and then not modifies that. So either one of those may not, have the privilege or something. That sounds negative. Waive the privilege sounds negative, but the two of them together basically says we keep the privilege. Is that clear as mud? Or law is full of double negatives, some of them very obvious and some of them a little bit subtle. But you have to work on those because otherwise, if you read quickly without analysis, you can get all messed up. And I don't use the word confused. You're not confused. I dealt with confused people. Sometimes they had to be taken care of in nursing homes and so on. They walked around and they would ask where they were, Am I at your house? No, you're at the law office. Your daughter's going to help you. Somebody would be climbing a ladder when there was nothing to do. There was no light bulb to be changed, and then fall off the ladder. That person is confused. You're not confused, but you can get mixed up a bit, okay? And one way to get mixed up is to read too quickly. Waiver is a negative thing. You're giving up something. Not is another negative. So you may keep the privilege. Well, here's another one, inadvertent, another disguised negative, basically accidental disclosure, not on purpose, right? So what is inadvertent? That's another negative, not on purpose. You see all the negatives that lawyers can put into a sentence? Negatives, qualifications. It helps to chart these things out. I actually write out little sometimes chart it. I mean, literally sit down there and write down on a piece of paper. Apparently, penmanship sometimes is better than typing for memory, but chart it out. You can look at laws too, and laws are written in the negative, but sometimes there's too many negatives. And here's your live classroom quiz words, which is just the two words mental impression, okay? I know I'm going long, but we're dealing with stuff that not everybody has a grasp on. And again, if you don't know the context, call me. It doesn't make sense. How to preserve privilege and work products. So we've spent a lot of time working on privilege and working on work products, so it makes sense. What I did does not replace your readings, though, okay? So use the readings and contact me. Okay. Yeah, that was those two words. Yes. Yes, this is the assignment. The problem is they want copies of communications between you and the client and the timeline. Now, do you see that why I wanted the communications to be clearly labeled and not have them look like business documents? Does that sort of fall into place? Opposing counsel requested copies. Normally, we have to give out all the copies of documents we have.
I don't get the question, Mr. Olson.
Normally, we have to give out everything that are all documents, but not if they truly qualify as work product. The question I posed that does it make sense that that I tried to explain why we wanted these things as more of a letter to the lawyer rather than to look as a business document? We don't really want them to create new business documents and then give them to us.
Yeah, but the lawyer is right? It says your attorney believes that these documents are privileged and has refused to turn them over. That
Right.
is covered under the work product thingy earlier?
Yes, and but of course, it's purposely vague, so you have the ability to argue both sides a little bit, okay?
I'm sorry to say this, but I don't get the question again.
It's
What is the question?
Your course competency is to explain how to preserve privileged communication and work product.
Oh, so it has nothing to do with this scenario?
Yes.
That was just a reference?
Well, we are going to write about privileged communication and work product and do an application of that.
Okay.
And what are you going to do? You need to know both sides. Some communications could be privileged and some may not be, which is what I was explaining.
How are we able to determine what's privileged and what's not?
You will not be able to make a final judgment necessarily. You will just explain the law on both sides. So you have a template, opposition to motion to compel. So you want to research the issues and talk about privileged communications. You have to try to argue that the timeline is actually work product and is not something that is really factual. So it's not just about the timeline, it's also about communications. And of course, we don't know for sure yet whether the communications were done properly. Seeking advice. Or whether they are a document, business document. So without knowing, you're going to end up trying to show some law on both sides. I will say, I think the timeline, I don't think we need to discover that. The exception to that, though, is if we're actually going to use the timeline in court and show it to the judge and the jury, I think we're stuck disclosing it anyway. But if we just use that for our own purposes while plotting strategy, I think you're going to find that you do not have to disclose the timeline. The timeline was not created by the client as a business record. It was created by you as a paralegal. Now is it starting to come into focus which things might be work product, which things might not be? Okay. Yeah, it's important to realize that some documents, most documents, we're going to lose. They're not work product. They're just simply documents that the client has always had, and we cannot recharacterize, we cannot repurpose those as part of our strategy. Well, the documents that the client has are all our strategy. No, they're not. They're factual. We did not produce them as our work product at all. We just got them from the client. So we have to turn them over. But certain communications, though, with the lawyer are really under lawyer-client work product. And the communications back, communications from the lawyer are protected by the privilege and work product. But you need to show the sources. You can't just use me as a source, okay? Use your state's rules and laws, rule statutes, case decisions, not just Kirk Olson, okay? Sources, okay? Now I think it should be in focus pretty well. Okay. You should use the motion template to support your arguments. Include case law, statutes, or rules. So work until you get stuck, and then let me help, Lexus help, tutoring help, whatever help you feel you're ready for. No, I want you to use the standard template because otherwise it makes it hard to grade, hard to see what you came up with, Leah. But just do the best you can. But being stuck is not bad. Being stuck is common to any high-level work. This is high-level work. Being stuck is good. You should get stuck, and then you should get stuck at a higher level next week. Okay. Leave the caption as it is. Template continued. Fill in the law and arguments where indicated. So they have these things, law and argument, law and argument. C and D as well. Your law and your argument as well as you can do it. And you may use lesson content, but I would prefer that you use state law because that will advance you. And get help. Get the help indicated. So work until you get stuck. Let me help. Lexus help. Tutoring help. And I am going to stop the recording. Thanks for waiting. I realize this took us a long time, but I think this is high-level stuff. And even those of you that have the experience, I think a lot of you are saying, well, I have experience doing it, but I didn't realize we'd have to do this much as paralegals. Well, you don't always, but this is high-level stuff.